you have started a business and you are selling a particular good or service using a name or using an image or using a combination of an image and a name. You're probably hashtagging these names or words on your social media platforms. Part of my job as a trademark attorney is to help clients navigate that process, which can be sometimes very confusing. The applications can be very long. Clients often come to me when they are at the beginning, they haven't filed an application and they'd like us to do them. Other clients will come to us when they've already used possibly an online legal service, or they have attempted to fill in or complete or submit the application on their own. And now the state authority or the federal authority, the United States Patent and Trademark Office, has now issued something we call an office action, which is basically a challenge to your application. We want to be able to mitigate, meaning eliminate, reduce the chances of some of those mistakes happening so that your investment can be more cost effective. It's very, very difficult to have to tell a client that an application was filed incorrectly or that there's a prior registration that could have easily come up in a search. Because of that, we have to start over. So let's talk a little bit about the difference between a state trademark and a federal trademark. A state trademark is exactly what it sounds like. You register your brand name, logo, slogan, whichever brand identifier you're using in connection with your goods and services within your local states. This is actually something that's very, very, very common for cannabis retailers. Cannabis is legal in many states, whether it's medicinal or recreational. If you are a business owner or an entrepreneur that does not have any intentions of expanding beyond your home state, you would have an opportunity to file for a state trademark. That would give you exclusive rights to your name, logo, or slogan within state bounds. You also have to use the mark that you register consistently in order to preserve your rights to that particular mark. Some of our clients and people that I've spoken to feel that once they register, that's it. It's very common for some of our clients to change their branding. They'll register one mark and then they'll decide that they want to rebrand. The key to that is to make sure, one, that you're using the marks that you're registering so that you don't lose your trademark rights. Let's talk a little bit about what you need in order to begin the application process. So the very first step to working with us in the trademark registration process is to pay for a comprehensive trademark search report. That report will tell us at the state level, at the federal level, domains, social media, and pretty much any digital platform or presence that the mark that you searched has. If there's a prior registration, if there's a pending application, someone who owns the domain already, that is a very big deal for a lot of people watching this video, because most of you will buy the domain and then do the trademark search and find that the name is already registered. So that's why these searches are very important before you start the application process, because once we submit a trademark application to the federal or state government, those fees are usually not refundable. Generally, there is a little window of about 10 days when we submit it. Sometimes voluntary amendments can be made, but it's very tricky. I would not rely on that. You really want to make sure that what you're submitting is as accurate as possible. And that is the advantage of working with an attorney. Someone like myself who is experienced will know what to look for, will examine the report, will let you know whether it is worth it to move forward or not with your particular name or logo. Trademark registration and management is not cheap. The state and the federal government will bill you based on the number of classes in your application. This is the rule. For one application, you can submit one mark. One application, one brand name, or one logo, or one slogan. So an attorney like myself who is filing these for you is probably charging you a flat fee or is charging you per hour. Trademarks are a lot of work, and so we don't really know the amount of time it's going to take. Every brand is different, every submission is different, every client is different. Some clients are more responsive than others. Some get us, the evidence and the files that we need quicker than others. So please bear with your attorney, and if they're explaining these things to you, just realize that this is an investment and it's a process. Trademark registration is a process, and it's a long process, right? It could take a year. During COVID, it was taking 2 years, 3 years. So be patient and budget for this expense, because it is very important and it gives your business a lot of value, but also you need to budget and you need to plan for this expenditure. So if you have a budget for your business, you should be budgeting for legal expenses, whether it's to register your business or do that kind of legal housekeeping, or to register your trademarks. So at the state level, right, if we're registering in New York, that's going to be 3 classes at $50 each, $150 plus legal fees. The USPTO charges $350 a class. So if you're doing retail store services, t-shirts, and mugs, you got to do $350 times 3. $700 plus $350, I think that's about $1,050. So your application fee would be $1,050 plus the cost of your attorney's fees. A lot of our clients get confused. They assume that they can register 3 different marks, meaning a brand name, a logo, and a slogan all in the same application, and it just doesn't work that way. Each mark has to have a separate application. Each application can have several classes. Some clients will start with a name application first and then do a logo application in 6 months or the following year. Some clients want to do everything up front. They're already kind of on social media. They're already very active. We've worked with artists where they want to make sure that they own their stage name because they're going to sign with a record label or they're going to be in a film, and they want to make sure that they have the rights, the sole trademark rights to their name. There will be different challenges that will come up with the application, but that doesn't always mean that it's the end of the road. This is why it's very important to hire an attorney when you're ready to embark on the trademark process. If you have more questions about that process, again, I encourage you to reach out to us at galvisandcompany.com or info@galvisandcompany.com. You can also like this video, put your questions in the comments, and we can reach back out to you. But I strongly, strongly recommend that you book a consultation to speak with us directly.